Now I am going to dictate a legal passage at the rate of 120 words per minute based on latest Supreme Court judgment. Let's start. There has been a slew of litigations between the parties to the present suit or their predecessors in relation to the properties being the subject matter of the instant suit, claiming undivided right, title and interest therein and oblique or on the strength of the probate granted to the will of the original owner, namely Bidhubhushan Samanto. Para. The instant appeal arises from an order disposing of an application for temporary injunction holding that the plaintiff oblique respondent have made out a prima facie case and the balance of convenience and inconvenience lies in their favor, and in the event the injunction is not granted, they would suffer irreparable loss and injury. Para. The salient facts involved in the instant appeal are required to be adumbrated before we embark upon the legality and oblique or infirmity of the impugned order passed by the trial court. Admittedly, Bidhubhushan Samanto was the owner of the property described in the plaintiff of the instant proceeding and made and published his last will on 11/10/1958 and got the same duly registered with the sub-registry office. By virtue of the said will, the said testator, the Bidhubhushan Samanto, bequeathed his 1/4 share each in respect of the properties owned and possessed by him to his three sons, namely Govardhan Samanto, Lakshmi Narayan Samanto and Sam Sundar Samanto, and the remaining 1/4 share was bequeathed to other two grandsons, Somunath Samanto and Asit Samanto. Undeniably, the said testator died on 29/06/1960 and a probate application was filed by one of the executors for grant in solemn form after the citation was issued. The other executor, namely Vishwanath Samanto, lodged the caveat and filed an affidavit in support thereof, challenging the genuinity and the authenticity of the said will. The record would reveal that the said probate proceeding was convicted into a letter of administration proceeding and compromise was entered into, wherein the said Vishwanath Samanto was given 8 ana shares in respect of the entire properties. Subsequently, the letter of administration was granted by the competent court, but there appears some dispute amongst the parties on the effect and oblique or intricacies of the said letter of administration, which we will deal in extenso in the later portion of this judgment. Para. Subsequently, the said Vishwanath Samanto filed a suit for partition claiming 8 ana shares in respect of the entire properties on the premise of a compromise having entered in the probate proceeding, which was decreed in preliminary form by the trial court. Some of the parties to the aforesaid petition should prefer the first appeal, that is FA 364 of 1977. Before this court, the said appeal was allowed on 16/5/1991, setting aside the preliminary decree with categorical observations that the grant of probate cannot be circumscribed by any terms in the compromise. There was no further challenge before the Supreme Court against the judgment and decree passed in FA 364 of 1977 by the division bench of this court. Another suit being titled suit number 199 of 1992 was filed by the said Vishwanath Samanto for enforcement of an agreement dated 5/7/1967, which was entered into by and between the parties during the probate proceeding, which which was ultimately dismissed at the preliminary stage on the ground of its maintainability. There was no further challenge to an order of dismissal of the said suit before the higher forum. Subsequent thereto, the appellant number 1 herein filed title suit number 23 of 2011 claiming partition and separation of the shares, including some of the parties to the suit, which ultimately ended in compromise through Lok Adalat. Subsequently, the plaintiff oblique respondent filed a partition suit being title suit number 486 of 2016 before the trial court, which was dismissed for default on 4/4/2018 without making an attempt for restoration of the said suit being title suit number 486 of 2016. Another suit is filed by the plaintiff oblique respondent being title suit number 170 of 2019 for partition and separation of shares, in which an order of injunction is passed by the trial court, being the subject matter of the instant appeal para. The facts as enumerated herein above are more or less undisputed, but the respective counsels are not ad idem on the implication and the effect of the decisions rendered therein, and also on the effect of an award passed by the Lok Adalat. The preliminary objection is raised by the appellant that the moment an award is passed by the Lok Adalat, the same cannot be challenged by the plaintiffs by instituting a suit, as the remedy only lies by preferring an application under Article 226 or 227 of the Constitution of India. In support of the aforesaid contention, the reliance is placed upon a judgment of the apex court. It is thus submitted that though the plaintiff oblique respondent have filed a suit for partition, but in effect, stop. Thank you.